Director of Family Network on Disabilities. And we're going to be talking today about Senate Bill 1108 and our presentation, which we've titled A New Day in Florida, because we truly believe that the changes and advancements that we've been able to make through Senate Bill 1108 truly mean that a new day has dawned for families and parents of children in ESE in Florida and for schools and school districts. So let's get started. The first thing that I would like to do is to thank everybody who was involved in getting the bill passed. We here at Family Network were involved in drafting and advancing the bill, and we're very grateful for the opportunities to work with some wonderful people in making this happen. So I would like to thank Governor Scott for signing the bill. I would like to thank Senator Gardner, the primary Senate sponsor, for his tremendous work in making this happen, and Senator Thrasher as well, the primary sponsors in the House. I'd like to thank Representatives Brodeur and Manny Diaz in the House, the main House sponsors. And I'd like to thank all of the members of the legislature who co-sponsored the bill or who voted for the bill. This was truly a bipartisan effort, and everyone recognized that the changes that we were making were reasonable and that they would help families. I'd also like to thank very much the Foundation for Florida's Future and their tremendous work on the bill, as well as our colleagues at Disability Rights Florida. Working with the folks there was truly a pleasure as we pulled together to make this happen. So in the process of getting this bill passed, some myths were busted, and the biggest myth that was busted was the idea that you can't add to the parent rights that are found in IDEA, that it would be a violation of federal law to go above what's set forth in IDEA. My response to that is, well, if it's a violation of federal law, then how come lots of other states do exactly that? And if it's a violation of IDEA, if it's a violation of federal law, how come IDEA states specifically that if a state goes above those that are the requirements that are in IDEA, that they have to notify the U.S. Department of Education, and the Department of Education keeps track of those. It doesn't say you can't do this. It says, oh, if you are going to add to what we have here, please let us know. So clearly, even IDEA itself contemplates that states are going to go above what's set forth in IDEA. I again, am very, very happy that we've been able to achieve this and assign that particular myth to the dustbin of history. So the approach that we used was really looking at the parental rights in IDEA as a floor, not a ceiling, as a base to build on, not a ceiling above which we could not go. As I mentioned, this was a bipartisan approach. Folks on both sides of the political aisle recognized that these changes were reasonable, and we feel that it's important because we feel it's very important to recognize that disability issues are nonpartisan. They're not just bipartisan, they are nonpartisan, and this particular bill really, really passed or proved that notion. So we're, again, very grateful to everybody who helped make this happen. So let's talk about the major changes that SB 1108 brings about for families. And Again, I'm very grateful to Disability Rights Florida for this analysis. I've relied very heavily on their analysis in preparing this section of the presentation. And there are really 5 major changes. We'll go through each of those briefly, and then we'll talk about each in turn in more detail. With all of these, I have included a cite to both the section number of the bill first, and then the section of the statute, the Florida statutes, that is affected by that portion of the bill, so that I have a cite to a link to the bill later on. If you pull up that link, you'll be able to go right to the section of the text of the bill that has that, as well as looking up the statute. Okay, so the first is the freedom to bring a person of a parent's choice to a meeting without fear of coercion, harassment, or retaliation. That means anybody they want, anybody of their choice, they can bring to a meeting. The second is major life-changing decisions require explicit parental consent. What are major life-changing decisions? Well, they're things like placement. There's things like placing a student on a special diploma track. Those things have to be pulled out. They have to be discussed. They have to be explained. And the parent has to explicitly consent to those. The third is the right to have private therapists and other personnel to work with children in the classroom with the consent of the teacher and the principal. Teacher and the principal have to consent to time and place, but that right is explicitly there so that folks from outside who have been brought in by the family to help the child can work with the child during the school day. The fourth is the right to be informed of how much funding the school district is receiving for your child from the ESE budget. And that's very important, and we'll discuss that a little bit later. And then finally, there is a new process to follow to obtain an extraordinary exemption from standardized testing. This already exists, but again, this is a little bit of a clarification to the current process, so that the process now has specified time limits, it has specified requirements, and a specified chain, starting with the IEP team, going to the district superintendent, and then ultimately to the Commissioner of Education in Tallahassee. So those are the 5 major changes in brief, and let's now turn to looking at them in a little bit more detail. So the first major change is the parent's right to bring a person of their choice to a meeting regarding their child's education without fear of harassment, coercion, or retaliation against them or their child. This is very important, and it builds on the current right by making it absolutely clear that this means anybody, period, that the parent wants to bring to a meeting, they can bring. And they do not have to get the schools or school district's consent or permission to do that. There's no requirement that the person that they bring has to have special training, that they have to have special knowledge about the child, that they have to have any knowledge about the child. It can be anybody they want, from a professional to somebody who they simply want to be able to, rely on for emotional support, to hold their hand during the meeting, whatever it may be, they can bring them in to any meetings. And again, we tried to make the definition of meetings as broad as we possibly could, so that it doesn't just include IEP meetings. It includes 504 meetings. It includes, transition IEP meetings. It includes IFSP meetings. It includes every meeting that we could think of, to make sure that the message is straight and direct. Any meeting, anybody, they get to come, and then The paper has to be signed at the end of the meeting by the parent and the representative of the school district saying that harassment, coercion, retaliation has not occurred. So that's another significant change. Now, I'm saying this as the executive director of a parent-led and parent-driven organization. We've been around for almost 30 years, and we've worked with folks throughout the entire state. We know that most schools and most districts get this right. We know that most schools and most districts do not engage in this behavior. However, some do. And we have heard complaints from parents for our entire existence, from one end of the state to the other, that this has occurred to them. This section is specifically meant to bring this to an end. This is behavior that should not be occurring, period. And I have never heard anybody defend this when it's happened. So hopefully we're shining a light on this, and it will bring this to an end. So the major changes, again, the second one being explicit parental consent for major life events like alternative assessment, placement, being placed on the special diploma track. Once again, a separate form is required, and the parent has to sign. Yes, I agree. No, I don't agree. Now, what happens if the parent doesn't agree? Well, a couple things. Up until this bill became law, it was the parent's burden to initiate the due process if they wanted to stop whatever it was from happening. If they didn't agree with placement, change in placement, they would have to take the district to due process to try to block that. Now, the burden shifts to the school district if they want to try to enforce this. And the stay put provision is in place, which means that the child will stay where they are until and unless either the parent agrees or the district prevails at due process. So let me touch on that unless the parent agrees part, because I think that is the real key to this. I will tell you very plainly, we do not expect that this is going to result in a lot of litigation. I've heard that. I've heard the concern expressed by school officials that, oh my gosh, now, this is going to require us to sue families. No, that's not what it requires. Because just because a parent may not consent initially, it's not irrevocable. The parent can change their mind. They can go back and they can consent. And so what we fully expect is that rather than school districts running out and hiring a bunch of lawyers to sue families, really what we expect is going to happen is that parents and schools are going to engage in more meaningful discussions about the children in ESE. Because we have heard also from parents across the state for as long as we've been in business that they didn't realize these things were happening, that they may have signed something somewhere that had a consent to these particular things happening, but it was buried somewhere and that no one explained it to them, no one made it explicit, no one gave them the pros and cons, no one explained why they felt that their child should be in this situation or that this change should be made for their child. And we've also heard that, I may have agreed. I probably would have agreed if somebody had taken the time to explain this to me, but I felt like this was just forced down my throat, and I didn't want to go along with it because I didn't understand. Well, more information, more discussion. Why do you feel that this is the appropriate thing for my child? Okay, fine. Now I get it. I understand. Those types of discussions. And I can tell you, as a licensed attorney myself, it is a whole lot cheaper to sit down and talk with parents and talk with families and explain why the school district feels that one of these choices is appropriate for a particular child than going out and hiring a lawyer. And I can tell you, I don't know of a single school or school district in this state today that has lots of extra cash laying around to hire lawyers to sue families. So really what we expect is not litigation, but more dialogue between schools and families. So the question has already come up of stay put where. What does that mean? And it's come up a lot already in the context of, well, you know, the decision about placement that I didn't agree with was made at the end of the last school year, before SB 1108 became effective. What do I do now, and where does my child go? We're having the first IEP meeting of the year. I'm not going to consent to this placement, but what does that mean? Does that mean they go back to their prior assignment? If you look at Section 4 of the bill, Section 1003.5715, subparagraph 6, and that's the site right there, that says current educational assignment. That's where they stay until the due process is resolved. So if a change has already been made, as a parent, you can not consent to that, but they're going to stay in that current educational assignment until, again, either you consent or the due process is resolved. The third major change is the one involving private instructional personnel. And this includes a number of categories. Again, try to make this as broad as possible so that we didn't spend a lot of time arguing about whether this person or that person has the right certification or qualifications or degrees or this, that, or the other. We tried to make it as broad as possible. And we tried to address the very valid and legitimate concerns of teachers and administrators that they didn't just want somebody essentially barging into a classroom whenever they felt like it and saying, you know, I'm here to work with Johnny. So the teacher and the principal must consent to the time and place. But that is a consent to the time and place that is not the right of absolute denial. Teachers and the principals cannot say, no, there is no time that we have available where this person can come in and work with this child. It cannot happen. It also does not relieve the school district's obligation to comply with IDEA and or provide the child with a free and appropriate public education or FAPE, and that's the standard under IDEA. So what is this supposed to mean? This is supposed to be, one, collaborative, and the statute makes it clear that the private folks that a family may bring in and the teachers are supposed to collaborate for the education of the child, for the best interests of the child. So it's not a situation of the teacher is going to be teaching one thing or enacting one strategy and the private person coming in is going to be doing something completely different. This is meant to be an extra layer on top of whatever the school is providing. And that goes right to the last bullet there. This is not meant to relieve the school of its obligation to comply with IDEA. It's not meant as a substitute. It's meant as a supplement to whatever the school is required by law to provide. So the school can say, oh, great, you're bringing in somebody? Okay, fine, then we don't have to provide this speech therapy, for instance. We don't have to do that anymore. No, this is above and beyond whatever the school is required to provide. Okay, the fourth major change is the right to be informed of how much district is receiving for your child in ESE, and this is to occur at the first IEP meeting of the year. If any of you have tried to track the funding over the years that an individual district may receive for each child in ESE, if you've ever tried to come up with this number, you know that it can be very, very challenging. And it can be challenging just because of the complexity of the funding. There are lots of different streams. There's lots of different programs. You know, not all of it is necessarily spelled out explicitly that, oh, this is, you know, for students in ESE. So coming up with that number can be difficult. Well, now this is a requirement, and we feel that this will be helpful for everybody. Now, what this is not is money follows the student. In other words, this is not setting a budget for your individual child for ESE services for the year. For instance, let's just say the first IEP meeting of the year, you sit down and the representative of the district says, okay, for your child and for every other child at your child's level in the funding matrix, we receive $5,000 a year. So you sit there and say, okay, well, you know, $5,000. Again, that's not your individual budget, but it is a tool that everybody can use. And I mean parents, teachers, administrators, everybody. You can look at it and say, okay, well, am I really getting that value? Is my child really getting that value? Is my school getting that value of services for the students that we have here in ESE? And if not, then again, we hope that that is going to spark discussions with policymakers, with the folks who decide the budget, and make sure that, you know, ultimately that the most benefit is being derived from those funds for kids in ESE. Then finally, the last major change is a new streamlined procedure to request an extraordinary exemption from standardized testing. Now, we do not believe that this is a provision that is designed to open the floodgates, as it were, and result in lots and lots of exemptions from any type of standardized testing in Florida. That's not the way the state law reads. That's not the way that the federal law reads. That's not the direction in which the feds are going. In fact, they are decreasing the availability of exemptions rather than increasing. So we really expect that what this will be used for is those cases where students with the most significant and extreme disabilities obtain exemptions when even with accommodations being provided and implemented correctly, that whatever the testing is still doesn't measure their ability because of the extent of their disabilities. So in those cases where, regardless of what can be done with the testing instrument, it's still not measuring the student's abilities because of their disabilities, then this exemption is appropriate. Now, there are some significant requirements here. Yes, it's streamlined. Yes, it's explicit. But you need to be aware that if this is something that you're going to be looking for your child, you need to start as early as possible in the school year because the first requirement is that you can't make this request any later than 60 days before the date of the test that you're seeking an exemption from. So that's 2 months. And as you know, 2 months can go by really quickly when you're talking about, kids in school. So 2 months, and the process starts at the IEP team level. And if you look at the statute, you will see that it requires extensive documentation. So really, you're talking probably a process of a minimum of 3 to 4 months, if not longer, to put together a package and then to schedule an IEP team meeting and then to discuss that and come up with a recommendation. Now, if the request is, yes, this child really should be exempted from this testing, then that goes to the district superintendent, and he or she has a certain amount of time to make a decision. If they agree, then the recommendation goes up to the Commissioner of Education in Tallahassee, and he or she again has a certain amount of time to make a decision as to the recommendation. If the family doesn't agree with the decision at the various points here, there is a dispute resolution process as well. So again, we don't expect this to be utilized very much, but it is a new and more explicit procedure. So the bill also makes some other changes that are important and that I wanted to go over. The first of these is the BPI requirement, and BPI stands for Best Practices in Inclusive Education. And this is an assessment that is required to be conducted by each school district and each school in conjunction with FIN, the Florida Inclusion Network, and this has to happen at least once every 3 years. Now, we think this is very significant. Really what we're talking about is the process where FIN comes in and works with the district and with the schools to identify the things that are working and the areas that need improvement. So for those of you who are familiar with the continuous improvement process, this is really what this is designed to be. Wherever a district, wherever a school may be in successfully implementing inclusion, just like everything else in life, there's always room for improvement. They may be doing a fantastic job. There's always areas that can be fine-tuned. There's always areas that can be improved on, and they should be quite rightly recognized for those things that they're doing right. So that's the second bullet on the page, that the results and all of the short and long-term improvements in the plan that is designed, they have to be included in the district's ESE policies and procedures. So everybody can see, what this is, public record, and you can see the plan. Now, I would suggest that everybody who's listening to this, whether you're a parent, family member, teacher, administrator, be aware of this process as it's going on in your district, and try to get involved, try to have input, try to have a seat at the table, because it's very important that that kind of input occurs as this is going on, to make it as meaningful as possible. So there's some other changes to charter school funding, and this doesn't add any funding to charter schools, but it streamlines certain currently existing reimbursement processes. I'm not going to spend any time on it because, again, it really doesn't make a change other than that streamlining of processes that already exist. The second bullet on the slide is concerns standardizing definitions of the places where children in ESE are educated. And what has become apparent in the last year or so is that many districts around the state were educating students in ESE at a variety of places that they would call a variety of things, and not all of those were necessarily contemplated or described in state statute or regulation. So rather than having all of those different approaches, all of those different places describe different things, meaning different things, where different types of things may be taking place, this section of the statute says, okay, we are going to have these following categories. Everybody is going to call whatever place they may be these things, and these are the types of things that will happen in each of these categories. So makes it cleaner, makes it more streamlined, makes it more uniform, so that we can just understand and compare data more readily, and we can be aware for accountability purposes of where a child is and what is supposed to be happening at the place where they are. Last bullet there concerns school grades and accountability again, and it involves who receives credit for the scores of ESE students. What this section of the bill provides is that the scores of the ESE students will go back to their home school, with very limited exceptions for those with the most severe disabilities. Now, this was the subject of a great deal of discussion, and many folks said, well, you know, we don't want to penalize teachers, we don't want to penalize schools. No, that's not at all. And from a parent's perspective, we're not trying to penalize anybody at all, but we very properly have the expectation that when we send our children with disabilities to the school to be educated, that somebody in that system is accountable for our child receiving the best education that they can. Very simply, very straightforward. It has to be somebody's job to be making sure that that happens. Not that our children are placed somewhere where their scores may not count, or they may not count fully, that they're counted and that their education is given a priority. So that's what this is designed to do, to make sure that that accountability takes place. And finally, beginning July 1st of 2014, all educators who are seeking certification or recertification will be required to have at least 1 hour of continuing education in the area of teaching students with disabilities. This is part of the current total. It's not in addition to, so it's not something on top of what educators are already required to do. But it has to be part of this, and this was in direct response to what, again, we have heard over the years from educators and from pre-service educators, and that includes the 2 of my 4 children who are teachers, is that they were not prepared in the course of their education and certification for educating students with disabilities, working with their families. This is designed to be a start to address that. We hope that will help to address that situation. Here are some links to more information about SB 1108. The first one there is a link to the bill itself on the Senate website. It's very useful. The bill is not very long at all, and I would encourage you to get a copy of it. The second one there is a link to the Florida DOE's website that contains a guidance memo that has been recently issued by the DOE for districts on the implementation of 1108. Very useful, very helpful, and it includes some draft forms. It includes draft forms for the provision preventing or prohibiting coercion, harassment, retaliation, and it includes draft forms for the consent for the life-changing events that we discussed. The form for prohibiting coercion, harassment, retaliation is a voluntary form, but the other forms are not. They are mandatory. And they're mandatory to be used by the districts while rulemaking is going on. Some of the provisions of the statute require rulemaking by the department, and I want to thank the department for their efforts in having already initiated the process of rulemaking for 1108 and moving forward with that, and their efforts in getting out this guidance memo and these forms. We greatly appreciate it, and we greatly appreciate their efforts to make sure that 1108 is implemented swiftly and effectively. Again, there's information at other places, but this is really very, very useful information to have. And if you have any other questions or need any more information about SB 1108 or any other topic regarding disabilities, please contact me, Rich LaBelle. There's all of my contact information. FND is a cross-disability organization. We serve all people with disabilities of all ages and their families. If we can help you, if we can help your children, if we can help your family members, if we can help your friends, please let us know. Give us a call, send us an email, send us a fax. Go to our website. We have lots of free information there, and we look forward to hearing from you. So thank you for your attention, and again, please let us know if we can help. Thanks.